Hi, everybody. I think we'll go ahead and get started. This is very loud. Welcome to our panel on Racial Justice Act. I'm really excited about this panel because this is one that demonstrates how we can have really fruitful, meaningful, productive partnerships between practitioners and academics. I'm Elsa Chen from Santa Clara University, and I just want to quickly introduce the other people on the panel, and then we're going to turn over and have the three separate presentations, and then we'll have Q&A. So first I'd like to introduce Elizabeth Lashley Haynes. She's a public defender from Los Angeles County. Then we have Lisa Romo from the Office of the California State Public Defender. Mona Lynch from the University of California, Irvine. My colleague, Patrick Lopez Aguado from Santa Clara University. And Daniel Portman from the Santa Clara County Public Defender's Office. And without further ado, I'm going to turn it over to Mona and Lisa for the first presentation.
Should we both get up? Do you want to? I don't know. No, just one. Hi, everybody. Thanks for joining us. Oh, there we go. As Elsa said, I'm Lisa Romo, and I'm from the Office of the State Public Defender, which is, our office is just on the other side of the bridge in Oakland. And I am a racial justice attorney there, so I spend all of my time working with attorneys to develop resources so they can litigate RJA claims and reaching out to experts like all of you. So I'm going to give us a background of what the RJA is, just so we're all on the same page, and then my colleagues will talk about specific applications that they're working on. So I think it's important to think about where the RJA came from. It's really a groundbreaking, unique statute. A couple of other states have RJAs, but they're specific to death penalty. So our Racial Justice Act covers all cases, and it was prompted by decades of court decisions that greatly constrained the defense ability to litigate racial justice, racial discrimination in our cases. And that's true primarily for two reasons. The first is that the cases set an extremely high burden for proving the existence of racial discrimination. And even if you could meet that burden, then there was a second hurdle, which is the harmless error doctrine, which basically said that we had to affirmatively prove that any racial discrimination or bias in the case actually harmed the case and prejudiced our client. So it's a very high bar. And perhaps the most notorious of these cases is McCleskey versus Kemp, which was decided by the US Supreme Court in 1987, and I'm guessing you're all pretty familiar with this. So McCleskey was a death penalty case, and it was out of Georgia, and the late David Baldus did a study with his colleagues that examined the use of the death penalty in Georgia, and they found out when they controlled for a large variety of factors that black defendants who kill white victims were 4.3 times as likely to get the death penalty than people who killed black victims. And I see my little clock is not working, so someone tell me when 10 minutes is up. And the Supreme Court, the United States Supreme Court said, so what? So what? They said basically, it was a split majority, 5-4, but the 5 justices in the majority said, well, racial discrimination and disparities are inevitable in the criminal legal system. And under the Equal Protection Clause, we have to show both proof of intentional discrimination and by a specific actor, so not systemic, and then we have to show actual prejudice. And of course, this burden is virtually impossible to meet. And so one of the fortunate things that McCleskey did say is that states were free to come up with their own standards. So it took a couple of decades, but California eventually answered that call. And AB 2542, the Racial Justice Act of 2020, was introduced by Assemblymember Ash Kalra, who probably not coincidentally had been a public defender. So AB 22, which became the Racial Justice Act, was designed to change these legal standards that nobody could meet and to recognize implicit bias, so not just intentional bias, structural bias, and also that racial bias is inherently harmful. So one of the things that is so powerful about the RJA is it came with a set of uncodified findings. And while these aren't binding on the courts have really been looking to them carefully in order to interpret the RJA, and they have been very, very helpful in our cases. So they're extensive, but I just wanted to highlight a few because I think they are so powerful. The first is that race discrimination has a deleterious effect not only on individual criminal defendants, but on our system of justice as a whole. And this is something that's been challenging in the courts because courts are very used to dealing with individual defendants. And so we are trying to get them to look at systemic problems. And like I said, it has been a challenge, but because this language is in here, because the RJA was very clearly designed to address systemic as well as individual injustice, that we are trying our best to get the court to understand that, the courts. The findings also say that everyone possesses implicit bias. I'm sure this is not new to you all, but it is new to the judges on the California bench. And that current law has been insufficient to address discrimination. So this law was specifically designed as a countermeasure to McCleskey. And that also any amount of racial bias is a miscarriage of justice under the California Constitution. And again, as I'm sure you all know, trying to affirmatively prove that that some kind of bias has had an impact. I mean, if it's implicit, if it's unconscious, how do you prove that it impacted a juror, right? So the idea is that the mere fact that it happened is enough. And then the desire that the defense has, well, everybody has access to all the relevant evidence we need. So I want to go over what the RJA says. It was codified in Penal Code 745A, and at its heart, it's pretty simple. It says the state shall not seek or obtain a criminal conviction or seek, obtain, or impose a sentence on the basis of race, ethnicity, or national origin. And it has what we call 4 pathways. So there are 4 different ways to get to a racial justice violation. The first 2 are based on conduct, and the last 2 are based on systemic disparities. So A1 is when there's bias outside of the courtroom. And that occurs when we have a judge, attorney, and that includes defense attorneys, a law enforcement officer involved in the case, an expert witness, or a juror who exhibits bias or animus toward the defendant because of that person's race, ethnicity, and national origin. And as I talk, I'll use race, but that's a shorthand for 3 things: race, ethnicity, and national origin. So what might an A1 claim look like? Well, here was a particularly egregious one. The investigating officer was in a bar with the prosecutor and some other people after a court proceeding. And at that court proceeding, the defendant had been charged with arraigned with some additional charges. And so I guess they were celebrating. And the officer used the N-word. It was very egregious, very obvious. A2 is similar, but it's when this conduct occurs inside the courtroom. So it's the same group of participants during trial and in court used racially discriminatory language about the defendant's race, ethnicity, or national origin, or otherwise exhibited bias or animus towards a defendant, whether or not purposeful. So in contrast to these conduct-based pathways, sorry, I got ahead of myself. Here's an example of an A2 claim. So in this case, the defendant took the stand in his own defense, and the prosecutor was asking him about his skin color and whether it was true that people did not realize he was a black person because of his light skin. And he said yes, totally irrelevant, right? And then in argument, the prosecutor said that the defendant had bragged about fooling women with his good looks and, quote, admitted to having an ambiguous ethnic presentation, and that people did not know, or who didn't know him thought he was something other than black. So the idea that somehow, because of his relatively light skin, he was fooling people and therefore was not a credible witness. So then we have the disparity claims. Those are A3 and A4. A3 deals with disparities in charging and conviction based on the defendant race. A4 is about sentencing. So A4A is disparities in sentencing based on the defendant's race. And then A4B is sentencing based on the victim race. So for example, in homicides, we know that those are largely driven by race of victim. the disparities in homicide charging. So I want to give you an example of an A3 claim. I'm actually going to talk about the language because it's a little convoluted, and we are still fighting out in the courts what exactly it means, what exactly our obligation is. But under A3, the question is whether the defendant has been charged or convicted of a more serious offense than defendants of other races who have engaged in similar conduct and are similarly situated. And the evidence establishes that the prosecutor more frequently sought or obtained these convictions for more serious offenses against people who share the defendant's race in the county. So yeah, it's a mouthful, and we are busy litigating exactly what it means. There is some language in the definitions that help us a little bit. We know that more frequently sought or obtained means the totality of the evidence demonstrates a significant difference, and the prosecution cannot establish race-neutral reasons for the disparity. So we are looking holistically at a totality of the evidence, and importantly for you all, that does not mean statistical significance. So statistical significance is a factor the court can consider, but it is not required, and we can present statistical, non-statistical, or aggregate data. So an example of an A3 claim was in a gang case. The case looked at everybody who could have been charged with the gang murder special circumstance, which subjects a defendant to either life in prison without parole or the death penalty, compared two groups, and found out that the black defendants had a much higher risk of being charged with the gang murder special circumstance, even though the eligible white people were not being charged. So, excuse me. I just want to emphasize that although these are pathways, it's more holistic than that. So we can combine our claims to make one violation of A. The court has said it's a broad scheme that covers every stage of the prosecutorial process through investigation, charging, trial, conviction, and sentencing. So what could go wrong? Well, first of all, we're really coming up against data challenges. I don't know how many of you have tried to get data out of California, but I see heads nodding. We have a very decentralized system. We have 58 counties. Each can have their own process. We do have a California State Department of Justice that collects information, but they aggregate it at a very high level, and so it's not useful. We don't have it by county, and they are reluctant to give it up. Hopefully we can talk a little bit more about that. And then we are having a really difficult time getting courts to understand what it is you all do and how you go about assessing disparities. So we go in with different kinds of statistical analysis. We go in with regression analysis that controls for all kinds of things. So we can say, look, these people are similarly situated. And the courts say, oh, well, that's nice, but what you really need to give us in addition is you needed to write up narrative descriptions, so basically qualitative evidence. You need to write up narrative descriptions of cases that are just like your client, but where the defendant's got a more lenient charge or sentence, and we're a different color. And so we're really having a hard time trying to convince the courts that while that can be very persuasive in some cases, qualitative evidence, quantitative evidence is good too, or both, but we are really having a hard time getting the courts to understand that, regression analysis or risk ratio, if you have carefully constructed comparators, should be enough. And so all of the people here on this panel have faced that, so I'm going to turn it over to, well, first I'm going to turn it over to Mona.
So thanks, Lisa. So as Lisa described, the California RJA is really a revolutionary in terms of its breadth, applying not just to death penalty cases, but to all criminal cases. And it also has actually a retroactive component, so it can go back in time for certain kinds of felonies before the law even passed. And it's revolutionary in design as well, by allowing for very individualized claims of bias in defendants' specific cases, so that's in those A1 and A2 sorts of claims, as well as more general disparity claims based on what we call similarly situated analyses of disparities in charging and or sentencing at the county level jurisdiction. So I think for criminologists and for related social scientists, this law offers both an opportunity and a series of challenges. So let me first talk about the opportunities. So some of us in this room have served as experts in criminal cases, perhaps even frequently, but typically those opportunities do not involve us applying our craft, actually going out and doing research, especially when we're working at the trial court level. Rather, we may be called to discuss research finding, including our own findings in our areas of expertise. And these are typically one-off engagements specific to a given defendant and to the particular circumstances of that defendant's case. In some sense, those 745A1 and A2 elements fit within that model. The 745A3 and A4 elements distinctly do not. It's here where I think social scientists have the opportunity to obtain and analyze data at the county level and present findings in a way that is much more analogous to what we do as researchers, and on a topic that's really a core concern for many criminologists. So many of us study inequalities, disparities, and so on in the criminal legal system, and here's this law that allows us to do it in a way that can directly impact a defendant's life. So CRJA has really kind of changed the landscape in terms of our expertise and having a direct effect. It's much more sort of hands-on in some ways than is doing policy work, even though that's pretty applied. So consequently, it can be an immensely important and rewarding space for us to conduct research. It can give us potentially access to county-level data that we otherwise can't get, and particularly prosecutorial data, which I think many of you know is extremely hard to get. The big black box, as my colleague O.J. Mitchell called it, of criminal justice data. And it offers us a chance to bring empirical research to the trial level courts in a way that can directly benefit those who are impacted by racial, ethnic, and national origin inequalities. At the same time, though, as Lisa described, this endeavor can be challenging due to data access and data quality issues. More fundamentally, it can be difficult to bridge the epistemological and knowledge divide that, between how our distinct fields work, law and social science. When lawyers seek experts to do these disparity analyses, there's a lot of sort of work to be done to be able to be on the same page about how that's going to proceed. Those challenges are sometimes accompanied by risk and potential discomfort for social scientists. Unlike in the policy context, doing empirical work in the criminal legal system is to enter into an adversarial space that can, at times, be antithetical to our norms, expectations, and values when we do social science. How so? Well, most obviously, and probably least important, is that the law dictates the parameters of our research questions in this context. In the case of the RJA, the inquiry is both narrower than what we typically focus on, and that's in terms of like defining what's meant by similarly situated. It's also relatively atheoretical as a function of the law's elements, asking whether disparities exist, not why they exist and how they're produced. More daunting, though, is for the social scientist in this context is how the work gets evaluated. We in social science have a well-established, albeit sometimes flawed, sometimes really dysfunctional system of peer review, typically double-blinded, that evaluates what we produce on the social science side, and that's done by our peer experts. Entering into the trial court context nearly ensures that we will face a hostile reviewer, the prosecutor, whose goal is not to assess whether the data and analyses support our conclusions, but rather to discredit those findings and even in some case discredit us as scholars. In that adversarial process, prosecutors may even have their own statistical experts to bolster their claims that we're wrong, leading to a battle of experts over the truth. The ultimate arbiter of whose analyses are right and whose conclusions are right is also not a peer expert, but it's a judge whose orientation to statistical evidence can vary considerably from befuddlement to hostility to thoughtful engagement. And this leads to a more structural issue that comes with this working in the RJA, partly because it's so revolutionary and such an important law, both for the state and potentially nationally, which is that bad outcomes in individual cases in this context can lead to bad law for the CRJA itself, essentially chipping away at what is a robust commitment to racial equality in the formal law by its application in the criminal legal system. So the stakes are high to overcome the epistemological and knowledge gaps and present our findings and conclusions in a way that is consistent with our scientific norms and expectations, but that are also understandable for legal actors without our methodological training. And we need to make that fit within a law that both allows as evidence and requires as evidence that's sufficient to make a claim. And we must do this in the more pugilistic system for determining whether racial disparities are present or not. So how can we do that and help ensure that this law provides access to racial justice as is its intentions? First, we can take lessons from existing work, particularly the death penalty context, and Lisa talked about the Baldus study, so that really set out kind of a standard for how one can approach working on disparities and documenting disparities within a legal context. More recently, I turned to Catherine Beckett's work up in Washington State, where the state Supreme Court outlawed capital punishment based upon her statistical analysis of capital cases in that state. So while Baldus's work ended in the horrendous McCleskey versus Kemp decision, it became a model for how social science can integrate statistical evidence within legal standards in a way that continues to serve as a model for us. And it's a blueprint for racial justice challenges to this day, including the one that Catherine did in Washington State. Second, this law operates at both the case level and at more structural level to promote racial justice, and it's important for social scientists working in this field to communicate and develop a set of standards about how CRJA statistical analyses are conducted and interpreted. There's great potential to develop a community of scholars around this law, given the breadth and frequency of the potential claims that are happening in the state, and they're huge. There's a huge number, both in terms of the retroactive cases and the ongoing cases. And right now, there's an emerging network of social scientists trying to do this, and we welcome more voices. And you'll hear about a happy hour tonight that you'll be invited to if you'd like to join. We have flyers up here for that. And in building this community, we can address some of the knowledge gaps in our field on how statistical studies get retrofitted into a legal framework, including the norms around report writing, how to present findings via that Q&A style of direct examination and cross-examination, as opposed to the narrative style that we work in, and in addressing the issue of statistical significance, which Lisa mentioned, when working with, say, a full population of cases, where you don't need to extrapolate to a population, or when the N is so small that there's insufficient statistical power, even when you get what appear to be large effect sizes. We can also better partner with the defense community to ensure that they are able to seek the appropriate data needed for analyses and to facilitate shared expectations about how those challenges are managed. And we're going to hear from two more pairs of people who are going to talk about those in specific cases. So thank you.
So thank you, Lisa and Mona, for a really great introduction to the next two presentations. Elizabeth and I are going to talk about the nuts and bolts of working together on 745A3A4 claims in a little bit more detail that reaffirms some of the points that Lisa and Mona made, and also provides a little bit more insight on some of the complexities of working together as practitioners and academics. So I'm going to turn it over to Elizabeth to start. Oh, actually, let me start by telling you, Elizabeth is going to start with some general information about how RJA attorneys and social scientists who do the data analysis can work together. And then we're going to go through a couple examples, a 3 strikes RJA case that has been resolved already, and then how we're thinking about future opportunities to build cases on three-strike sentencing and resentencing.
Okay, so I'm an attorney and I practice in Los Angeles. I solely do the Racial Justice Act, so this is all I do all day long. Elsa and I were discussing what kind of cases are we interested in, and they're the types of cases that we have seen and known who practice criminal defense, and we know that the racial disparities exist already. Cases such as disparate police stops that lead to arrests, cases of forensic bias, issues where there might be autopsies where possibly the coroner is using or looking at it from an implicitly biased framework, which results in certain kinds of cases being filed by the DA. The ones that are really ripe are examples of like gangs, guns, who gets charged with gun charges, wobblers, which, you know, is either could be charged as a felony or a misdemeanor, and who gets charged with the felony, who gets charged with the misdemeanor. Pimping and pandering and human trafficking are sort of a ripe area that we've been looking at because there's such incredible disparities by race. Sex offense cases are ones that are being litigated, another large disparity by race. So, and I don't know if you want to weigh in as well, but we were discussing sort of the difference, which Mona also discussed, which is right from the get-go when we try to work together as practitioners and experts such as yourself and academics, there's immediately sort of things that pop out that make it challenging. And I said to Elsa, like, if everybody only knew that the standard when you walk into court is so low, like you just take the stand and say what you're going to say and talk about your degrees and the court buys it like hook, line, and sinker. There's no like peer-reviewed process. There's no, it's like, oh, you're very smart and you've researched this area. Great. We accept what you're saying. You know, the standard is anything that is basically outside the common knowledge of a layperson, okay? So I've worked with quite a few academics so far, and I've had people say, like, I don't really think I'm an expert in this field. I'm like, oh, you have no idea. Yeah, you're far more of an expert than, let's say, the judge or me or a juror, right? So that's what we're looking for. But we've realized that in the academic world, the standard for which you practice and you do your work is really high. You know, you hold yourselves and you hold your community to a very high standard. But those are very different from the legal standard in the courtroom. Mona touched upon, and I think Lisa touched upon, in RJA specifically with the database claims, we're realizing that there is a very quick and emerging problem because there's language around significance, and immediately we've noticed like that the academics are like, well, this isn't statistically significant, and we're like, but we just want it to be significant, like just big, right? So we have to watch what academic words mean in the academic context versus what those words may mean in the legal context. And oftentimes they're very different. So we need to always sort of be working through those language barriers and figuring out what that actually means in the courtroom versus the academic world. This is one of our favorites. So in the academic world, you all are trained and really pride yourselves on mentioning your limitations and your weaknesses of your research and of your papers, right? And we noticed this in a case we were working on where an expert wrote a report and they did sort of this standard thing that you all say about the limitations, and the attorney read the report and said, like, what the hell is that at the bottom? You basically undercut your entire opinion. Why would you put that in there, right? And they were like, well, that's what we're trained to do, right? So we are working through those challenges, and we're saying, like, oh, you never want to highlight the weaknesses of your work. This is adversarial. Like, you come in, this is strong, you know. If somebody wants to bring something up that's weak about your work, fine, we'll deal with that, right? So that's another big difference between the academic world and legal world. And another one is in the academic world, you all are typically functioning with very long timelines, or long for me, right? You're doing your research over a long period of time, and in the courtroom, sometimes always time is of the essence. So Elsa knows that she'll get a call from an attorney like, I have this big project I need, and can you do it in a week, right? And that sends all the academics' heads into a total tailspin. Because you have to remember, we typically have people who are incarcerated and in county jail, sometimes in prison, and so we really want things to happen quickly because our goal is typically always getting people out of custody or getting sort of justice to happen. Okay, so when we typically approach an academic, a professor, an expert, we sometimes have data that we already have obtained. And where are we getting this data? We are getting it from a variety of sources. It's typically coming from the district attorney's office, coming from CDCR, coming from Department of Justice, police departments. Sometimes we're getting it from like open data portals that are available. Sometimes it's internalized data if we have a really good data management system from within our office. Sometimes probation reports, and it's never perfect data, and it's almost always problematic, and we have to work with what we have. Again, we have a short timeline. So that is a source that's difficult between us and the experts that we work with because they look at the data, and I mean, I recently had a conversation with one of my experts, and we've been working on this for so long, and me and the other attorney said, look, let's just accept the premise that this data is trash, and I need you to work with the trash data that we have. And that's pretty much what happens. So that's really challenging, right? Because you all want good data. And we've got what we've got, and we need to get someone out of jail. So that's kind of how we're functioning. Yes. Did you want to add anything? Or am I okay? Okay. This is an example of a case, one of the sort of early cases that I worked on in RJA and how Elsa and I came to be working together. My client is an African-American man. He was in prison for 34 years on a third strike sentence. His third strike was not a big deal, and his 2 prior strikes were even what I would consider to be low-level strikes. Low-level robberies, like snatching things out of a grocery store and getting into a tussle with someone. His third strike that sent him away for this long was snatching a bracelet off of a woman, no injuries, no harm done to her. We had been litigating this case for a very long time. An attorney in my office in the post-conviction unit had been trying to get him all kinds of relief, Prop 47 relief, trying to get it reduced, Prop 36 relief, I think she had litigated between 6 and 8 years. She just was relentless trying to get him relief, and the judge would not budge no matter what. We didn't know particularly what it was about this client, but the judge just was giving him no relief. So the attorney came to me and said, you know, can we do anything from an RJA standpoint? And I said, yes, let's do it. So I knew that third strikes were implemented in a racially disparate manner, of course. As a public defender, I knew that. And so then I started crafting my motion, and I needed support for it, because there's 2 phases of RJA. You have to get through the initial phase to even get a hearing granted. So I was writing my motion to get through that initial phase, and I started doing research, like what is already out there? What's already been done? Who's already written on this topic? And so then I did sort of a deep dive, and lo and behold, I found articles on third strikes and racial disparities in California. Even better, as I kept digging, I found some with some research and some data that had been done specifically in LA County. And in RJA, you have to do it county specific. So here's an example. These were the articles that were popping up for me. Examining racial and ethnic disparities in California 3 strikes law. It's like, perfect, right? And they were almost all written by or a lot of them were written by Elsa Chen. And I'm like, I need to find this Elsa Chen, and I need to get to her, right? She was hard to get to. But when I finally got through and I said sort of like, hey, I'm this attorney and I'm working on the Racial Justice Act and you've written all about it and I really need your help, it worked out. What I did was I attached many of Elsa's articles to my motion, gave it to the court. It's like the work was already halfway done for me. And so then I got somewhere. I got past that initial phase. The judge found that I did enough, and we started preparing for the hearing. And lots and lots and lots of pushback from the judge. We just kept going, kept going. Should I tell the end, or did you want to get into it? Okay.
Prior slide.
On the prior slide, right. Judge eventually agreed to resentence our client after probably about 6 to 9 months of me litigating this. And the judge wrote a written opinion and insisted that his decision to change his mind had absolutely nothing to do with race. So I took that. So we didn't have the full RJA hearing in this case, which happens quite often. So what happened was we got the result we wanted, right? The client got resentenced. I would say that RJA had a lot to do with it. The judge would say it had nothing to do with it, but you can make up your own mind.
So when Elizabeth called me, I was just like, wow, somebody read my stuff? We usually spend all of our time just like writing journal articles so other eggheads can read our journal articles. And I was just thrilled that this was actually going to have a practical application and maybe improve somebody's life. And I was even more thrilled when I found out that it actually did, and the defendant was released. My prior research has compared sentencing outcomes for individuals of different races, ethnicities, and ages, while controlling for legally relevant variables, such as conviction offense and number of serious and violent priors. Turns out, this was kind of what Elizabeth was looking for. And I found racial disparities in the application of 3-strike sentences under the original version of the law in California, with black individuals most likely to receive 3-strike sentences. I also have found black-white gaps in sentencing outcomes have been particularly large for the lowest level felonies, known as wobblers in California. So that's related to discretion. And I've also looked at how demographic and political characteristics of local jurisdictions influence sentencing outcomes, including 3rd-strike sentencing. And there's a lot of discretion in LA County specifically. This slide is mostly for any attorneys who are in the audience, because the social scientists here will recognize that I'm talking about dependent, independent, and control variables. But this is an issue that comes up every time I hear from an attorney about Racial Justice Act. They tell me, hey, I've got this really great data set, right? And it's all the people who got 3 strikes, or all the people who got charged with resisting arrest, or something like that. And look, most of them are black. And I have to go, I can't use that, right? Because what I really need is people who are eligible to get that outcome and did and didn't get that outcome. And then what I need is a comparison group, so African Americans in this case, compared to white people. And this is sort of like Stats 101 for lawyers. The data, we might be able to work with what you referred to as like trash data, right? But not all trash data. So we really need to have some variation on the independent and dependent variables, the outcome, and the race and ethnic groups. And we also have to maybe anticipate some arguments that will be used to claim that the defendant isn't similarly situated compared to people whose outcomes were less severe. And typically we do that by controlling for current charges and prior record, but I've been getting into these great conversations with public defenders in several counties saying that's not a good way to do it, because we all know that current charges and prior records are also associated with racial bias. So I think it's a little more subtle than the way we typically do the control variables, right? And then we might look at other characteristics that are associated with the outcome, such as age or gender, but typically we don't have to go that far. So let me back up a little and mention some of the findings that in the studies that Elizabeth used. Really, charts like this are sort of where we start our research, but that's actually often maybe even enough. So here we can see, this was a 2008 study using CDCR data that found that African Americans were heavily overrepresented among incarcerated people, and more so among second strikers, and even more so among third strikers, and even more so when we were talking about wobblers, and also when we were talking about property and drug offenses. And those findings point to greater disparity where there's greater discretion in charging decisions. And that's kind of what we're emphasizing, right? Where you have discretion, you have room for bias. It may not be intentional, but it's detectable. And then here's what we're thinking about moving forward. In 2012, there was a ballot initiative passed called Proposition 36, and California has this habit of naming everything Proposition 36. So we have the one that was about the drugs, and then we had the one that was about this, and then we have this one about like felonies and misdemeanors this year. So this is the 2012 one. And it made two major changes in the law. So before Prop 36, if a person had 2 prior serious or violent strikes, any new felony could trigger a third strike enhancement. And hence, this client that we were talking about who had sort of a low-level new felony, but it was, a third strike sentence. And then the retroactive component of the law made some people eligible for resentencing. So individuals with rape, murder, or child molestation were excluded, but in addition to that, there's a whole portion of this Proposition 36 that says, in exercising its discretion, the court may consider other things like criminal conviction history, disciplinary record, and any other evidence that the court, within its discretion, determines to be relevant in deciding whether a new sentence would result in an unreasonable risk of danger to public safety. Oh my gosh, that's so much discretion. And in addition to that, prosecutors are able to contest petitions on that basis, right? So if we're trying to claim that black defendants were less likely to be sentenced and released, then we want to look at the outcome of resentencing, and the key independent variable would be race. And then we might want to try to focus on certain offense groups so the groups we're comparing are more similarly situated. So I'm now going to show some tables, but I'm not going to go in a lot of detail because this is a little quick and dirty, and I still feel a lot of shame as an academic when I'm presenting quick and dirty analysis. So, don't quote me on this, except maybe in court. So what we see here is that I started with 2 data sets from CDCR, including all the individuals incarcerated in CDCR facilities in 2012, before Prop 36, and in 2016, 4 years later, when Prop 36 had largely been, the retroactive part had been implemented. And what I'm trying to say is, like, first of all, among those people who look like they're eligible for Prop 36, is there a lot of disparity? And right now, you can see maybe not too much, right? So, but what you do see is, prior to the passage of Prop 36, black people made up about 30% of the prison population and 46% of those serving a third strike sentence, compared to their 5.8% of the population in California. And they're overrepresented among third strikes. Then we pulled out the subset of individuals who appeared to be eligible for resentencing under Prop 36. So these are people who had 2 or more serious or violent priors and whose current conviction was not a serious and violent felony, and excluded people who had the disqualifying priors. So we see that actually there are similar proportions of black, white, and Latino third strikers who are eligible for resentencing. Then we compared the groups of third strikers who met those criteria for resentencing before Prop 36 and the group who remained in prison 4 years later in 2016. And these were the people who were not resentenced and released, even though they initially appeared to be eligible. And what we see here is whites are the most likely to be released if they were eligible for resentencing, but not by a very big margin. So it's very close. And so Prop 36, in the end, and I am going kind of quick, so I'm sorry, because, Prop 36 did seem to correct maybe a tiny bit of the sentencing disproportionality, but a lot of the disparity remains. And a lot of people were hoping that Prop 36 would address some of the underlying racial disparity. and it's not really changing it very much. So there is still, if we look at this another way, we can see that black people still made up 42.8% of those who are eligible but still incarcerated in 2016. So most people who petitioned for resentencing got released, but really there's still a large amount of racial disparity persisting, right, in the people who are sitting in prison who have those 3-strike sentences. And, I'm not showing this here, but when we separated, so the evidence for racial bias in resentencing, not super strong, but the evidence of persistent bias in people who were sentenced and didn't get resentenced, that's still strong. And when we separated out resentencing outcomes by both race and offense category, we found that weapons possession seems to be where black people are benefiting much less than white people from Proposition 36. And that's important because weapons possession or arming is the category where the law expressly left discretion in the hands of prosecutors to contest a resentencing petition. So maybe if we're thinking about moving forward, we might try to look at people whose resentencing denials were based on arming, because there is some disparity visible there, or people who have sort of the lower level wobbler cases, probably not that many of those left. But this is kind of just the logic of how we think about these kinds of cases. And moving forward, we have a couple of options, right? Okay, you have to correct me if I say this incorrectly. But we can continue to find test cases and litigate individual cases. If those are denied, then those can go to appeals and then to the higher courts, and maybe we're just building case law that way. And then at the macro level, there might be an opportunity with enough resources and coordination to sort of work together, analyze large-scale data. Since we have so many different disparate data sets and a lot of evidence, maybe we can work together and the PDs can help us get the data and we can work on a bigger case. And that's actually the reason for this cocktail hour. It sounds like a lot of fun, so I hope you'll come. Okay, I'm going to turn it over to the next group. Thank you.
All right, thank you everyone. Thanks for coming in. I am Patrick Lopez-Aguado from Santa Clara University.
Good, afternoon now. My name is Daniel Portman. I am a deputy public defender in Santa Clara County, and I'm a trial lawyer. I'm not a specialist in the RJA, but I have been litigating RJA violations and claims in the trial court for the last couple of years. Patrick and I have worked together somewhat.
Yeah, and so today we wanted to spend some time talking about how body-worn cameras, and more specifically the footage from those cameras, can be used in RJA appeals. But we also wanted to take this as an opportunity to kind of walk through the process a little bit and hopefully kind of demystify what's actually entailed by participating in these collaborations. So
these are going to be claims that are a little different from what we've been talking about so far this morning. These are not claims that are based on something that happens in court or on a disparity in charging or a disparity in sentencing. This is what we're talking about is a very specific but also a very common type of RJA claim that arises from something that happens during the investigation of the case, and really most commonly something that happens during the law enforcement contact or the law enforcement interaction that often begins a case. A car stop, for example.
Yeah, so a lot of the videos will be of stops or arrests, and really we're looking at primarily interactions with law enforcement and how bias is discursively demonstrated, and particularly in cases where that bias associates a given racial or ethnic group with criminality or with criminal suspicion in some way. And I think it's really important to think about this in terms of, the implications or the consequences of that bias in the moment, right? Where it's not necessarily someone simply misspeaking, but oftentimes when you watch these videos, you can see how the kinds of biased assessments that are made on the spot become the rationale or the justification for stopping, searching, detaining, or arresting people. And in some cases can be used to intimidate people to try to get them to incriminate themselves. So some of the common ways that you may see this unfold through footage, right? Rationales for categorizing people or spaces as suspicious, characterizing ethnic symbols or imagery as some type of evidence of criminality, making presumptions about someone's criminal history or gang affiliation, which can also entail kind of asking about their probation or parole status, right? Questions about citizenship or promises to contact ICE as a consequence of a stop, mocking someone's name or their spoken language, or any language that compares people to animals or is dehumanizing in any other kind of way. And oftentimes this can be either explicit or implied, but that's also why the opinion's important, right? Particularly as forms of racism may be sort of coded or maybe kind of suggested, right? It's not always a blatant slur. So that becomes where this opinion becomes valuable. So in terms of, Daniel, if I could pose a question to you, how do you know when a case is a case is a good candidate for RJA?
So I think the starting point in this is something that I think Elizabeth was talking about earlier when it's the issue of discretion. And when it comes to charging decisions, there's a huge amount of discretion in a prosecutor's office. There's an even greater degree of discretion in a law, like a police officer's actions in any given vehicle code enforcement stop. And what we have as sort of a backdrop to this is a set of decisions from the United States Supreme Court which said essentially that the subjective intentions of an officer when they decide to do a search or decide to pull somebody out of a car or decide to stop somebody for the kind of vehicle code violation that people make all the time, the subjective reason for them making those decisions is not a basis to challenge their decision-making on a constitutional level. But it is in the RJA level. And so what we're looking for in a lot of ways are inequitable treatment and sort of, if something feels on sort of a gut level that it's unfair, they're being stopped for a really minor traffic violation that you just know that in this neighborhood, a white person would not get stopped for, right? Something like that. Something like, a lot of these are stories that we've heard from our clients for years. And they are, somebody like me who's been practicing indigent defense for 15 years, I have heard from clients for that whole time about sort of this just basic unfairness in the way that they are treated by law enforcement. With the advent of body-worn camera, we can now see that experience through their eyes because we actually do, we now have a video and audio recording of exactly what happens in these interactions. So, we're starting with our client stories and we're starting with our own sort of gut feeling. And then from there, we're using the body-worn camera to establish what happened. But what we're really, the next step and sort of where somebody like Patrick comes in is that what we may think of as just sort of a gut level unfair treatment may be something that can be proven with a researcher or somebody with a real background in the science of this area is actually demonstrably inequitable treatment. And that's where your expert comes in.
And oftentimes when working in this kind of collaboration, right, when an attorney's contacting you and they'd like for you to review footage for potential violations of the RJA, typically they'll have moments in mind, right? There's, where they'll say like, there's this point where they kind of say this to the person that they stopped and I wanted to get your opinion on it. And so as you're watching it, there might also be other things that stand out to you, right, as you're reviewing the footage. So, for example, right, if we have a hypothetical where we have footage where an officer is asking someone why they have some type of expensive item in quote-unquote this part of town, right? Your opinion should discuss how is the individual being racialized in this moment, what is being assumed about them, and oftentimes the implication here is probably that they suggesting that they stole whatever the item in question is or that they don't own it. But there's also something about place here, right? This part of town is also something that's being, racialized in that moment. So it's also important to touch on that, right? What is being assumed about, this given neighborhood, this given district. What does the census data tell us about who lives here, right? Who resides here, who's present here, and how is that shaping this assessment of the situation being suspicious? And oftentimes it will kind of reinforce, right, that opinion about how the driver is also being assessed in that moment. So from the review, the opinion then oftentimes is written up through a report or a declaration. So what do attorneys need from researchers at this point?
So generally the way a claim proceeds in this circumstance, and I just will back up for one moment and kind of describe how this plays out in practice. There's a motion filed by the defense attorney alleging a violation of the Racial Justice Act. And that motion is generally, or if it's going to be successful, should be supported by a declaration of an expert. And so where you are going with this once you hire your expert is that you're going to want them to generate a declaration that you can attach to your motion. And the purpose of your motion is it gets you into court on this claim. And the first sort of hurdle is to make what's called a prima facie case that a violation has occurred, which is a fairly low burden, but it is significant still, which gets you to the next stage, which is a hearing, which actually gets you into court where your expert might testify. And we're going to talk about that in a minute. But the importance of a declaration is that it sort of does a number of functions for the case. It is the, at its very basic level, it is the thing that gets the claim moving. It's what opens the court doors. But sort of at the next level is that it provides a roadmap. It lets the court know sort of what the narrative of this story is. Why is what happened in this situation important? And it gives context to it in the broader sort of world of social science. Finally, a really well-written and sort of strongly supported declaration can have the effect of sort of ending these claims with an early win, because they're going to be filed with the court and, of course, served on the district attorney. And this is something we're seeing play out in a lot of different a lot of these claims. A strong declaration is going to convince the district attorney that this is not something worth fighting, and a lot of these claims are being conceded without ever having an evidentiary hearing, just based on the strength of a declaration. So a really well-written and well-supported declaration can be enough for a win right there.
Yeah, so having one strongly worded and strongly, a strong opinion about it can be enough to really kind of make the point clear early in the process. I kind of like writing declarations, actually, more so than reports, basically because they're extended outlines. And so for each section, it kind of forces you to be direct, be concise, be brief with your points, right? There's not a lot of space for like theorizing about like neoliberalism and the carceral state and all these things, right? Like, not that you're wrong, it's just not helpful at this moment. So it kind of helps you keep focused, right? Specific to what's happening, right? This demonstrates bias because it also helps to use phrasing from the legislation when possible. So it's kind of like when we have to write to like mission statements or things like that. Helps keep those keywords in there. And when writing them up, I think it also helps to, when describing an instance or an example of bias that's displayed, to also provide some context for where that stereotype or where that trope comes from, right? To establish that, this isn't simply a misunderstanding, but no, there's a history of this narrative that's being kind of elicited here, right? So if we have a hypothetical situation where an officer is describing someone's tattoo of an Aztec figure as gang affiliated, right? Again, we have a form of imagery that's very specific, right, to a particular ethnic group. It's primarily going to be this one group of people that's going to get this type of tattoo. And so any sort of criminal assessments about that is going to be very focused, right, towards that group. But beyond that, right, I think it also bolsters that claim to highlight that much of the history of criminalizing Mexicans specifically comes from this kind of anti-indigeneity, right, where arguments that the reason that Mexicans were supposedly more criminal or more violent or bloodthirsty, came from this indigenous heritage that they had. There's a lot of even official police statements to this effect, right, in the 40s and 50s, and something that Mary Romero writes about pretty extensively as well.
So I think what this illustrates is the broader point that what we need to, and the reason we need experts who have a deep sort of knowledge of the history of these symbols and the history of these kinds of this language, is that we need to show it's not an isolated incident of somebody, as you said a minute ago, misspeaking, but we need to situate it in the broader context of California history, of Bay Area history, of the history of wherever you are litigating, in that it is something that is a piece of a larger story. And that is really, I think, one of the most important things that we're doing in RJA litigation is illustrating how the individual actions need to be seen in that larger context, and your expert provides that larger context.
So you mentioned earlier that the initial kind of declaration helps with that first hearing. It's kind of the foot in the door. I was wondering if we could really briefly talk about what is kind of the process of hearings that come after that. Right.
So if you make the first, if you get over the initial hurdle, which is showing that there is essentially showing that you have a plausible case to be made that a violation has occurred in this case, the next step is that you get an evidentiary hearing at which the burden is on the person who's alleging the violation to show that a violation has occurred. And at that hearing, that's when you will actually have testimony from the expert. You may have testimony from a competing expert from the prosecution side, perhaps the, in this case, what we're talking about very specifically here is violations that are alleged against investigating officers. Oftentimes the officer will testify, and or somebody from their department will. So that is often, what we're finding in this area is that we are calling upon people to testify who have never testified before. And this is unlike a lot of the expert witnesses in the criminal defense world who have, say, for example, somebody who is a firearms expert, or somebody who is an expert in DNA, and maybe they're a scientist and they have a background in science, but they have made an entire living as an expert witness. And a lot of what, there's certain sort of skills that they've developed, and they understand sort of how the game is played, so to speak, within the, what to expect during questioning. So I think that can be very, it's been touched on a little bit earlier today, that can be something that's really challenging for somebody that comes strictly out of an academic background.
Yeah, in general, I think like a lot of people, I find testifying somewhat stressful. It can be a little intimidating, and I think general tips to help kind of minimize that at least, take it slow, right? Take your time answering questions. Try to simplify things as best you can. So in many of the ways that we kind of break down ideas for our students, right, those skills are really valuable in the courtroom. Make sure you understand the question fully. Ask to have it repeated, right, if you're not sure about it, or if you're in an aggressive cross-exam, they're trying to kind of rush you a little bit, like, take your time, slow it down, could I get that question again? And you get to have notes, right? Can't read off of them, but you could ask for a moment to check them and then, speak then. But the notes are pretty helpful to have. And main thing is being confident in your own expertise, and especially as researchers, we've kind of all gone through some process like this where we've had to defend our ideas, defend our analyses, right? Your dissertation defenses, your conference presentations, right? Job talks, we've all kind of been in those moments. So you're definitely capable, right, of delivering in the same way.
Yeah, I think one of the most important things is your point about not taking it personally and don't get into an argument.
Yeah.
If you're arguing, you are falling into what and this is specific to cross-examination, that is what an effective cross-examination wants to accomplish. There are a lot of, sort of lines of cross-examination that may seem, I think, to the person being questioned that they're being very effective, or that they're really, they're exploiting a weakness in your argument, and a lot of times it just doesn't matter that much to the audience, and the audience is the judge. And just know that whoever has called you as their witness, they're going to have another chance to question you after that cross-examination is over. And if they think that there's something important that needs to be cleaned up or returned to, they're going to do that. And so don't, in that moment, don't try not to feel like I've got to win this. That's not, I think that's a really important point.
Yeah, I think that's perfect. Okay, and final thoughts, we're mostly thinking about kind of the broader impacts of RJA, although I don't know if maybe this would be best for the discussing. But at least in the immediate sense, what are some of the possible consequences of a successful appeal?
So, I mean, the immediate consequence for the client can be the dismissal of charges or reduction of charges, which is obviously very significant for that individual. But in the larger sense, I think we are seeing, we're seeing a lot of these, the response to a lot of these claims is that cases are being dismissed rather than, prosecutors are choosing to dismiss cases rather than litigate these claims. But I think the, what we are hoping is that the broader impact is that it's going to change culture within law enforcement, and that they're going to be more, a lot of this is unconscious bias, and the only way you can begin to address that is make people aware of it. And so we're hoping that that is going to be sort of a long-term outcome.
Yeah, and I think if nothing else, just kind of the logistical challenge of if you have so many RJA challenges coming all the time, and oftentimes if it's oftentimes a result of a particular kind of enforced policy with law enforcement, right, or the use of a specific expert witness or discourse that's permitted in the courtroom, right, gradually changing all of those, right, over time is also kind of the hope of this, right, to actually influence what are the decisions being made through this process, and hopefully in a more just way. Anything else to add?
I don't think so. I think we have a little bit more time for questions. Thank you all.
Thank you so much.
Thank you to everybody and to our discussant, Catherine Grosso, who is going to come and facilitate the Q&A and also maybe share some of her own thoughts.
Oh, just a thought or two, maybe. Hey, great to see you all here, and such a great panel. I mean, I really would start with just saying, you got such a wonderful overview of what it's like and what it's out there. And so, I mean, I want to just make a very few comments, and then I'd love to hear what questions you have, because those are the ones that we have such great resources to address. But first, I would just say again that if you didn't yet catch on to how incredible this statute is, then I'm happy to talk with you more about it. But it's extraordinary. It reaches every level of crime. It's not just capital, it's not just misdemeanors, it involves immigration court, and it's retrospective and prospective. So the potential for all of the research that you've been doing that you didn't think anyone was listening to or cared about, this is it. Like right now, the things that you didn't think that you had an audience for, things that you thought, I'm going to document this, I'm going to do it because it's right to document it, the RJA is listening. So it's listening to scholars and to the research of scholars, all kinds of scholars and all kinds of disciplines over many years, but then it's also listening to public defenders who have had these anecdotes, right, which is how scholars talk about your stories, like one-offs. That happened, oh, that's terrible. But they would say it happened again and again and again and again and again. And the RJA says, well, let's prove it up then. Let's get it past your gut and that's when social scientists can bring that together and try to move the gut level and the client's representation of their experiences into court in a way that can be cognizable. So I loved Lisa's starting point, like what could possibly go wrong? Well, these guys just made it all seem so easy. They just were like, it's gonna work every time. So one of the things I thought might be interesting to talk about more is for the experts, what experiences would you add to those that have been on the table? What are some different experiences of expertise? And for the attorneys, what's your first ask? Like, when you find someone, how do you even get started? And then maybe as they work on this sort of telling a little more of the stories, come on up to the mic with your questions. So who wants to start? Well, of course, we're going to talk about the flyers. I was going to wrap up with it, but I'm going to tell you all again that there are these awesome flyers, and you want me to read it even right now? In case we run out of time, so no one leaves. I'm going to read it because it explains what it is. It's the Data and Research Consortium for the California Racial Justice Act. The Data and Research Consortium, always known as the DRC, and you won't know what that stands for, is a collaborative network of academics, researchers, and data scientists, that's us, that exists to empower the implementation of the California Racial Justice Act by increasing access to data and fostering rigorous scientific study of racial disparities in the criminal legal system. The DRC is uniquely positioned with the right skill sets to address knowledge gaps and to do the translational work for legal practitioners to be able to implement the RJA with rigor. What this is, though, is an invitation for you to be a part of the DRC. So we're inviting all of you to join us at our networking happy hour, which is going to be at the S&R Lounge at Hotel Zeta, which is very near here, from 5 to 7 tonight. You should definitely pick up a flyer. You should share it with your friends. You should bring anyone who thinks they might be interested. I think there are lots of different ways to get involved. Did I do a good job?
Yes.
All right. Now, come on, tell us some more of your stories, more things. What do you think about when you think I was looking for an expert?
So I wanted to touch a little bit on something that Elsa brought up, because it's, I think, such an important point here, and a place where we are really looking to all of you for help. And it's the idea of identifying, when you're doing a disparate impact claim or a disparate charging claim, how you identify these different groups. Many of the issues that we're looking at are not issues that are easily determined by looking at a set of charges. So, for example, California has almost 24 what are called special circumstances, which are can be charged on top of a homicide to make that homicide eligible for the death penalty or life without parole. And many of these are factual things. For example, shooting a gun from a car and killing somebody is a special circumstance that can be alleged. Now, the challenge is finding, you can always, it's very easy to identify all the cases in which a homicide was charged with the shooting from a car special circumstance also alleged. How do you find the cases in which factually mirror that, but they did not charge the special circumstance? And that is a data science question that is really super challenging. And from my perspective as a trial attorney looking at trying to bring one of these claims, we're having a really hard time grappling with that.
And no one keeps track. Like, no one keeps track. There's no list out there of that list.
Right. I mean, you would have to say, well, do you ask for every single homicide that's ever been filed and then ask for the discovery in all those cases, or at least a probable cause statement to see if that case involved shooting from a car? That is that's a pretty
Getting hold of the
task.
facts is impossible.
Right.
Actually.
From the perspective of an academic expert, when somebody comes at me with a request like that, I'm like, yeah, you should get every single case, and make sure that you get everybody who was ever arrested for that, and then control for what all these circumstances and stuff. And they're just like, our data is trash. You're not going to get that, right? So, and then the other issue is, sometimes it's too much, right? You have to back it up and say, okay, everybody who is booked for that, ask the DA for whether that person was charged or not, right? That's a lot of work for the DA. And you have to figure out then, okay, we know how to do sampling. Maybe we can figure out how to do some sort of random sample, and we could look at a small universe, a small subset of that universe. But yeah, that's been the big frustrating thing for experts, right? Is you really can't make it as rigorous as we typically want it to be.
Right.
You want to say something, Mona? Were you trying to?
No.
Kyla.
Hello. I know half of you. I'm Kyla. I also want to add something kind of on the expertise aspect of it that came out. We did like an RJA working group, and I learned a lot from the attorneys that were there about not only courtroom strategy, but also the broader statewide strategy, and the fact that some counties are very resourced and some counties are not very resourced. And I want to put it out to experts and what I heard from attorneys, which was, if some counties can hire experts who are statisticians and want to have the most rigorous methods, and they do that and they insist upon it, that's going to cut off the knees of counties that can't hire experts, that can't do those sorts of analyses. So I think it's really important for us as academics to fully take off that hat, and learn from the attorneys in the courtroom, not only within that county, but also, like Lisa would kind of, I think, probably say statewide, and thinking like, what is this doing for the broader picture in terms of how resources are allocated? And holding our knowledge until it's absolutely necessary in that case, right? Let's not run regressions, right? Let's not run regressions, because if we do, then that judge might expect regressions in all cases. I think it's really great to try and help attorneys do their own work, because sometimes I think you just need a frequency table. So hopefully people in the room are interested in helping with that as well. But just that was something that didn't occur to me as someone who's trained to run regressions and do this sort of rigorous methodology. When that came up to me, I was like, oh, of course, we are resources, and we need to distribute ourselves very judiciously, I think, in this particular statute. So I just want, it's not a question, it's a comment, sorry.
Well, I want to respond to that and turn it into a question, because it's something that attorneys face a lot, and we call it burden creep. That basically in these early cases, we are trying so hard to convince these judges, and we're just, I mean, some cases, there's a death penalty case that's going on right now, and they're up to like 5 or 6 experts. And that isn't a model that's going to work. But on the other hand, we have a client, and it's our ethical duty to do everything we can to help that client. So it is challenging. Yep.
Hi, Kim Richmond.
It's going to be our last question. But
Okay, I testified in the first RJA case in San Francisco, and hi, Catherine, I think you know that case. One of the challenges was this requires an extreme learning curve on the part of judges, it seems to me, and we had a very intelligent judge, but one who thought, I mean, in the abstract sense, but who thought that they were a social scientist and knew data, and they really didn't. And I'm wondering, maybe this is a question for Lisa, what are there efforts underway to do broad range judicial education in California?
So we as a defense community are always asking ourselves that, and we are trying, but basically they are not interested in hearing from defense counsel. However, Kyla is, she put together a data college for us, for defense counsel, and so we've done that, and she's also interested in doing it for the prosecution and for the judges. So hopefully, if she can go forward with that project, that will have some impact, because, yeah. Yes, DRC.
we're just holding a cocktail hour, and you should get your flyers from me. And with that note, I think we have to wrap up. Did you want?
I just want to say before we do that is an important part that you can play. So you guys can be presenters at judges' trainings. They won't let Elizabeth and me and Daniel show up, but you guys can go and explain to them, how you do your work, and that will advance the cause immensely. Thank you.